This is Dr. David Shine, and welcome to Business Law 101. Now, one of the most interesting pieces of this situation is the collection of monies. And the Uniform Commercial Credit Code is brought up here on slide 18. And it says seller cannot take an assignment of earnings for the payment of debt. And this is a legal restriction. And so that we don't have people that are being conscripted to keep paying money. One of the things that's interesting about claims for money is a lot of young people do run up debts that they never pay, and the debts are so small, like $400 or $500, that the person never pays the debt. Well, one of the interesting things that happen is there are companies out there that buy these extinct debts. So in most states, enforcement of a contract is like 2 years for an oral contract, 4 years for a written contract. So they may have a debt, a credit card debt, that's over 10 years old. It's not enforceable. It cannot be taken to court. So they'll just out of the blue, since they'll do some research and find Jimmy Bob and say, hey, Jimmy Bob, you owe Chase credit card company $258, and we now own that debt. Please send us a check for $258. Or sign this piece of paper that says you're going to make several payments to pay off this $258. If you do that, then they've got you because you have reinstated the statute of limitations, not on the original debt, but on this special workout debt. Generally speaking, what I advise people to do is, because it's already not part of your credit rating, is to go ahead and let the UCC, Uniform Credit Code, or circumstances like that apply to the payment of the money, and not to reactivate the debt. Because again, if you sign a piece of paper that says, yeah, sure, I'll pay this over 4 payments, there is now a new contract that is enforceable by this collection agency, that and you have reinstated the debt that is, by definition, the statute of limitations is run. Now, I saw one of these that was sent to a college student, or a former college student, who had run out some cards when they were in their early days in college. And what was interesting is the note even said it, the fine print at the bottom, the letter from this agency that supposedly had bought the debt, the credit card debt, said, this debt is already untimely, and therefore we cannot sue you for this debt, nor can we report you to a credit agency for not paying this debt. Actually said that in little fine print at the bottom of the letter, but it was interesting because the letter made it think like, well, now we owe this debt that you owe to this retail company, and we're going to go after you now. But that's actually not very effective. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.